Oftentimes, entrepreneurs start worrying about legal implication when it's too late and when they actually have some legal troubles. I have a good news and a bad news. The good news is that entrepreneurs don't actually need to know or take actions when it comes to legalities. Let me explain this a little better. We know that entrepreneurs have this tendency, this bias towards action. The entrepreneurial mindset, the entrepreneurial behavior, the entrepreneurial initiative. This is all about taking actions as a way to learn, which works. To create a venture does not work when it comes to legalities. If you don't know the legalities beforehand and you just learn whilst you're doing it, this can actually be very dangerous. So this is the good news. Entrepreneurs don't need to take actions. They need to hire and rely on the expert advice of lawyers and often also accountants, CPAs that can complement the offering by lawyers. So what is the bad news? The bad news is that entrepreneurs minimally should know the principles, the general principles of business law, in particularly corporate law, which is a branch studying how companies operate. Why so? Because most of the ventures will be operated under a legal entity, a juristic person. So the entrepreneur should know the mechanism that guarantee the functioning of his or her own business. Also, entrepreneurs should have an understanding of the principles of contracting and also an understanding of different legal systems. We know that entrepreneurs will eventually scale their business regionally or even internationally. When you go internationally, you will find a lot of different legal systems. So it's important to at least grasp the main differences between legal systems. In this video, you will learn how to select a lawyer, when you need to select a lawyer and when you can just do some research on your own to have this first-hand understanding of relevant laws and regulation. You will also learn a bit of history about legal system and why it's still important to minimally differentiate among the principal legal system worldwide. And then we will get to some basic definition of contracting and of business law. Let's kick off the video then. First of all, the entrepreneur does not have the experience to comply with all the law and regulation, doesn't have the experience to also foresee, predict all the possible legal risk that he or she will encounter, especially when promoting innovative business. Of course, when you are doing some innovative business, think of bioengineering, for example, you are going into heavily regulated industry with federal, FDA, so the Food and Drug Administration, which could be, like Food and Drug Administration in the US, but the equivalent of a Food and Drug Administration in any other jurisdiction. So besides establishing a legal entity, you also need to face this additional regulation coming from the FDA and other regulatory authorities. And this will minimally take a few years to go through all this process. Very recent examples are the vaccines against COVID-19, which have been approved all under the emergency proceedings, taking only a few months rather than the usual years long application with the FDA, the Food and Drug Administration. And this is pretty much the experience that we have seen in every legal system worldwide. So here the point is, when you are dealing with innovation, you may actually need even further legal advice than a normal, traditional type of company, because you need to understand how to navigate the legal risk posed by these new innovations. Legal systems. I mentioned this word already a few times in the video. So what are we referring to by legal system? So a legal system essentially is a categorization which we use to combine together, to group together countries that share similar principles, similar foundations in terms of legal rules, regulation, way of thinking, legal way of thinking, and so on. So the two major legal systems worldwide, and here there is also a map highlighting these two major legal systems, and then all the possible combinations of legal system are the civil law legal system and the common law legal system. So both legal systems, the civil law and the common law legal system, originated from the West, and precisely they both originated from Europe. The civil law legal system is the legal system of continental Europe. So the root of the civil law legal system date back thousands of years ago, and specifically they date back to the Roman law. So the legislation and the rules that were created and applied more than 2000 years ago, first under the Roman Republic and then under the Roman Empire. And in the first centuries after Christ, this is the period when there were major codification, so a collection of all the Roman laws, and this is the source, the first source of the civil law system. So this is the origin, a very ancient root of a civil law system. Many institutions that we are still using right now, they come right from the Roman law. Many institutions, for example, related to real estate, property, and all the real estate related rights, they come right from the Roman law, still now, after over 2000 years. A turning point in this system was the so-called creation of a civil and commercial code. And this happened first in France. This was under the age of Napoleon, so it's roughly 200 and something years ago. And this was literally a turning point, because with the creation of a civil code and a commercial code, scholars collected, categorized, refined, improved all the existing legislation, and consider that back then legislation was rather confusing and was legislation that had been created over 2000 years. So there were some principles, some legal institution coming right from the Roman law, then there were like some other institution coming from the Middle Age, and so on and so forth, including then the laws, the statutes enacted by the French government over the centuries. So what happened roughly 200 and few years ago? The French government was the first to say, okay, we need to create a code. We need to make this legislation clear. We need to categorize, organize all these very confusing amount of laws. So this is the key characteristic of civil law legal system. So the legal system that we define as civil law always display a civil code and a commercial code that of course is routinely updated. And this is a sort of a core. This is the most important law. It's not the only one, but it's the most important one in the jurisdiction. What more, the laws are interpreted or observed to the letter, meaning that in the civil law legal system, the expert judge decide on the interpretation of the law. So the judge will not refer too much to precedents. So this is kind of like the high level categorization. Then of course judge will also help in their decision making refer to some precedents, but the real point here is that the judge will apply the law. So what is the most important actor here is the law, primarily the civil and commercial code, and then all the other laws passed by the government or by the parliament, depending on the country. This legal system, as you can see in the map, is widespread. It's not only in continental Europe any longer. The first country, as I said, to create this code was France, and then all the other European countries followed. So it was a German code, it was an Italian code, it was a Spanish code, and so on and so forth. In considering the colonial domains of most of European countries, of course, like Spain and France at the forefront, but also other European countries had colonies in South America, in Africa, and some also in Asia Pacific, including Southeast Asia. Vietnam, for example, used to be under the French, and the same go for Laos, for instance. So many of these former colonies, when they became independent, still they adopted the civil law system because they deemed this to be a better system to regulate legislation in or the relationship between businesses, people, government within the country. You can also see that Thailand is a civil law system, and this is because Thailand, when it decided to adopt a modern legislation, so it look around, and then the decision was that a civil law system would have been the best choice for the Thai legislation. You can find in Thailand a Thai civil and commercial code, which is still one of the most important legal documents, foundational documents, which we will also refer in this video and in other videos, because, for example, the discipline of companies, the discipline of contracts is regulated by the Thai civil and commercial code. What is the other major legal system? The other major legal system, again, originated from Europe, but did not originate from continental Europe, but originated from the United Kingdom, from Great Britain. This is the common law legal system. What is the common law legal system? This is a system which is based on a judicial precedent, or as it's called as case law, which means that originally in this in Great Britain there was no written act, statute, law passed by the parliament or the government. So the law was actually made by the judges. So all the body of laws was initially developed by the judges. And the judges, then they just made a reference to a prior decision, and the judges, the court, were bound to follow the reasoning that was used in the prior decision. This is what we define with the Latin sentence stare decisis, which means when you judge decide on the case, you must follow the reasoning that was adopted by a court in a prior case. So this also is a quite popular legal system because, again, through the colonies of Great Britain, the first one being the United States of America, but other colonies include Australia, include Singapore, include Hong Kong. So this was the legal system adopted in all the former colonies of Great Britain. And given the economic power of Great Britain first, especially globally speaking, right? So, and then the economic power of the United States later on. So, of course, this to an extent, even though was adopted by fewer countries, since this is the law of the United States. So it's very common, very popular at international level. There is also certain bias of American business people, American investors, to prefer common law over civil law or other legal systems. And this is a very important point for startup owners, because Thailand is a civil law system which generally does not rank as high as a common law system in the preferences of venture capitalists coming from America or coming from the UK. And thereby, Hong Kong, Singapore do have a special space in the heart of American investors because they share the same legal system. From the map, you also see that there are some mixed legal system. So mixed legal system means that this legal system combines some of their local legislation, local habits, local customs with either the common law or the civil law legal system. One case, for instance, is India. India, even though was formerly part of the British Empire, but when India became independent, so then they adopted a sort of like mixed system. So not being completely following the common law, but they have a codification, so they have their own codes, which is a typical feature of a civil law. So India is one of a major legal system that represent like this sort of like hybrid system between common law and civil law. Okay, so this was the first important categorization, important differentiation. Key points here are, especially from a startup perspective, if you're looking for investment, keep in mind that venture capitalists generally would like to invest their money in a legal system which is the same of their home country. And as long as venture capitalists will be primarily American venture capitalists, of course, they will have a preference for Singapore and Hong Kong in Asia Pacific. Other important point is when you scale up, when you start having operations across many geographies, the first point to consider is, are we in a common law, are we in the civil law legal system? Because the principles are different. Even the reasoning, the legal reasoning is different. So you need to be aware of this because otherwise there could be some major issues. Okay, let's now move to the second clarification. The second clarification is to understand where to position business law. So, and let me give you here a case from Thailand as a representative of a civil law country. So Thailand is a civil law legal system. Within a civil law legal system, we have a Thai civil law. So Thai civil law means all the private laws, all the laws related to private business, private individuals. So here there is no legislation related to the government, criminal or public administration and so on. So we do not consider this. When we refer to Thai civil law, this case will be only the legislation that regulate relationship between individuals, families, marriage, contracts, and between individuals and business without having the government in the picture. Within this, the civil law, we have specific field of the law, which is business law. Then we will see that actually under business law, we do have a lot of like sub-branches from corporate law to intellectual property and so on. But this is just a high-level overview. In the same, we can apply to a common law country. So we have a common law legal system, Singapore, Hong Kong, UK, US. When then within the legal system, common law legal system, we have a civil law. So all the rules, regulation overseeing the relationship between people and other people, between people and private businesses. And then we have business law. So this is the second major clarification. Contracts. So again, here we are just giving some little definition to understand legal concept. So what is a contract? A contract is a legally enforceable agreement between two parties, as long as some conditions are met to make this legally binding. Of course, we have like some informal type of contracts. So the type of contract that will be only stipulated, concluded with a handshake. However, for important contracts, there should be always a written agreement. For some areas, for example, real estate or vehicles, you need a written contract, and especially in civil law system, you also need to register the real estate. So you need to register with the land department, or when you buy a car, you need to register with a land transportation and so on. When a contract is valid, so a contract is valid when, of course, it's not against the laws, when the contract is duly signed, and if a contract is signed by a company, it should be signed on behalf of a company by the duly authorized legal representative of a company. A few things to consider before signing a contract. So you need to understand the terms and conditions. If you do not agree with something, you need to ask, you need to clarify. If there are blank spaces, always make sure to cross them out, because blank spaces then can be filled out later on and you don't even know this. So that's why in a contract we always avoid to have any blank spaces. When you are negotiating the contract, it's actually good that you use the review mode on Word. This is just a prompt, but it's good because then you can see all the modification. It's actually much easier for you then to understand during the negotiation what are the things that are changing in the contract. One important point to consider, especially for young people, so countries generally have a minimum legal age, meaning that below a certain threshold, people are not sui juris. Sui juris is again a Latin expression which means being able to sign a contract and to act legally in the legal system. So again, you need to check in each country what is the legal age, because under a certain age, people are not allowed to sign a contract. If they do so, will not be deemed as a valid contract. So this is just a very brief introduction on contracts. What do we need to know more about contracts? So it's important, especially when you operate internationally, to understand what will be the applicable law to international contracts. So if you're stipulating a contract in the same country, in Thailand or in Singapore, not a big deal, right? Because you will say we are applying the Thai laws. Even if you do not specifically say that you are applying the Thai laws when you're signing a contract and both of you are in Bangkok or in Thailand, anyway, the law would be automatically the laws of Thailand. But when you do international contract, you need to specify what laws you are applying. And so here you need to remember what we discussed earlier. So we need to remember differences between common law and civil law. If you are a Thai company or a Thai person, you may not want to sign an agreement with common law, because then you may not be so aware of a principle, you may not be so familiar with the principles of a common law, you may prefer a civil law. This coming just from my experience. In Italy, Italy is a civil law country. Thailand is a civil law country. Italy has a civil code. Thailand has a civil code. Italy has a commercial code. Thailand has a commercial code. Many principles that I find on the Italian civil code, I also find in the Thai civil code. So for me, I'm very familiar with the principles, with foundational rules of a Thai system, even though I never studied Thai laws. But the reason is that we share exactly the same foundational characteristics. So I'm much more comfortable with the Thai laws rather than with, just to say one, with the laws of the UK, even though Italy and the UK are just a few thousand miles apart, 1,000, 1,500, compared to Italy and Thailand that are like literally of the opposite of the word. But legal principles in Italy, legal principles in the UK are completely the opposite. So again, why it's important to know civil and common law? Because as a rule of thumb, you may prefer to use a system which is closer to your own system. Internationally, you can also use some other ways, some other rules. For example, you can use commercial customs, you can use UNIDROIT principles. So these are all like international trade norms that you can refer to. Instead of referring specifically to the law of a country, you may say internationally, we would like to refer to, for example, UNIDROIT principles, that are some principles enacted to regulate international transaction. One warning here, very important. When you select the law for an international contract, you need to avoid a conflict between the law that you select in the agreement and the court that will decide on the agreement. Example, an Italian company and a Thai company, they do business together, distribution agreement, they want to negotiate a distribution agreement, they negotiate a distribution agreement, and then Thai and Italian, both civil law, then they say, okay, we apply civil law legislation, civil law, because we are familiar with it. And let's say they choose the Thai law. But then they say, however, we would like to have a court that is independent, meaning a third-party court, to decide in case there is any dispute. And so they may say, okay, we will do this with Singapore. In Singapore. So they defer any litigation before a Singaporean court. And this is a big red flag because Singapore is a common law country. So in case there is any dispute, then these two companies will go to a Singapore country, to Singapore, which is a common law country. And this poor judge in Singapore will say, oh, I need to apply the Thai laws. And even though I can translate the Thai laws in English, still, this is a civil law system which I don't know anything about, which I don't understand. So, conflicting. Important point here, and this is actually something that I've seen as a mistake in many contracts. Whenever you negotiate the governing law and the dispute resolution, meaning the court that will decide on that contract, make sure that you are matching civil law with civil law, common law with common law. If you want to go for Singapore, so then choose Singaporean laws, or you choose American or UK laws, at least the principles are the same. Okay, a few more important things to remember. So one is business law. So we have discussed so far about like relationship between private individuals and businesses, and then specifically the business law area. So what is the business law area? So this is a body of law that applies to all the rights, relations, and conduct of person in businesses that are doing trading, merchandise, and so on. So in the area of business law, you will find a lot of different sub-branches, from commercial contracts to intellectual property, corporate establishment, bankruptcy law, and so on. One interesting area of business law is corporate law. Corporate law is essentially the law, that branch of the law, studying specifically companies, how to set up a company, how to operate a company, the governance of a company, and so on. So here, an important point to remember. Whilst you can choose the law to apply to a contract, both a domestic and international contract, you can always choose. You can't choose the law to apply to a company. Meaning, if you want to set up a company in Thailand, you need to follow Thai laws. If you want to set up a company in Hong Kong, you need to follow Hong Kong laws. So this is an important disclaimer to keep in mind. Hope you enjoyed this first rapid immersion into first different legal system, civil law and common law legal system, and then a bit more in specifics in business law area and what are the important points to remember when concluding a contract, especially at the international level, when pursuing an investment, and when setting up a company. In the next videos, we will see more in details about business law and specifically company law. Stay tuned. Thank you for watching. Bye.